consent to the other side. Hearing of this matter stands adjourned for 4 weeks, least again in the third week of May 2025.
Apologies. My lord, I beg to mention item number 2, my lord. In this case, my lord, I'm filed with an affidavit in a reply, my lord. So, my lord, my prayer is, my lord, to call for the records, my lord.
Yes.
May I please, your lordship? Lordship, I have prayed for listing of a contempt petition for orders, lordship. May I pray, lordship? Lordship, can I take up this matter on
No,
the next week?
you tell the register, enter it in the registry, they will do it.
My lord.
Yes.
Please, your lordship. Your lordship, I would like to mention for listing of an item of WBC 3765 along with WBC 3766 of 24 on 3rd of April.
Go and tell it to the register, he will do it.
Much obliged.
May I please, my lord? I am on behalf of the petitioner lordship. I have to mention one matter for vacating the stay order in the case of the Assam State Warehousing Corporation versus Navjyoti Mishra.
Register. You know where it is? Hey, register bench, put as a local.
Like daily list for addition item 1.
Lordship, I senior Mr. HK Das is on legs in another. Kindly after some time, Lordship, for the time being.
This is a first matter, is on legs in which court?
Lordship, in 14, Lordship.
Huh?
14, Lordship.
You do it on some other day after Bihu. A prayer for adjournment has been made in this case on behalf of the writ petitioner on the ground that the counsel, arguing counsel, is busy in another court. In view of the request made by the petitioner's counsel, hearing of this matter stands adjourned for 2 weeks, list accordingly.
Lordship, a date kindly.
After Bihu vacation. It's a partner matter, it will come.
Much obliged, Lordship.
May I please, lordship? Lordship, my friend just mentioned about the reply. It is not in the records here. So we have written a requisition slip to call for the
You
record.
take time, then let it come up next week. Along with you have filed a rejoinder.
Yes, your lordship. We have filed a rejoinder.
When did you file it? When did you file it?
You know, it was 24 March.
24 March. And what is this matter about?
This is regarding the transfer of the petitioner. He has been transferred. So we have challenged the transfer on a medical grounds. We asked him to be that he is medically unfit. So they are supposed to submit this report. He was called in the medical board for examination, but the report was not submitted there. They admitted the medical report board was there, but no record was there.
Who is appearing for the respondent? Mr. Your name, please.
AK Gogoi.
Mr. AK Gogoi, Learned Counsel for the petitioner submits that the rejoinder affidavit submitted on behalf filed on behalf of the petitioner on 24/3/2025 is not on record. Therefore, the matter will be listed again along with the rejoinder affidavit. None has appeared for the respondents, although the name of the learned CGC is shown in the cause list. Be that as it may, on the request of the petitioner's counsel, let this matter be listed again next week along with the rejoinder affidavit.
You on the interim
Order passed earlier to continue.
Oblige, lordship.
May I please, lordship? Lordship, matter may be taken after some time, lordship.
Sometime is difficult today.
Lordship,
Why sometime after some time?
other side is not present, lordship.
Other time you argue. We allow-
Senior counsel Mr. K. Chaudhary will argue.
Then you seek for you are seeking for adjournment.
Lordship, they are also not present, lordship.
On the prayer of petitioner's counsel, this matter stands adjourned for 2 weeks.
Lordship, date may be given, lordship.
After Bihu.
May it please your lordship. Lordship, here the petitioner who after retirement from our High Court lordship as PS to the Honorable Judges lordship, he was engaged as a consultant PPS in the Armed Forces Tribunal lordship. Then lordship, the remuneration was fixed. The consolidated payment, etc. were given to him. Then he agreed to that and he joined the service and lordship, the consolidated remuneration was fixed at rupees 80,000 per month, lordship. Thereafter, in 2020, he joined.
So you are ready for final disposal, is it?
Lordship, lordship.
Yes.
Yes, lordship.
There are 2 writ petitions.
Lordship.
Two writ petition.
Two writ petition, same lordship,
Yeah.
same issue, that reduction, but amount is different.
Same petitioner?
No, lordship, one is Mr. Manavendra Chakraborty, another is Jagannath Datta, two. But their position are different, lordship. But he is Mr. Jagannath, lordship, Manavendra Chakraborty is lordship as consultant TPS. And Jagannath Datta is consultant JAO, Junior Administrative Officer, lordship. So their scales are different. Fixed remunerations are different. So I have made two different.
All right.
Lordship.
Let us see the facts of which writ petition you want to refer to.
Lordship, first one.
First and second, I don't know. What is the
Lordship, the
number?
WBC number 4972, lordship.
49?
72 of 2024.
Yes. Yes.
Here, lordship, the initial appointment order is at page 20, lordship.
Yes.
Page 20, lordship. May I read it? Lordship. Sri Manavendra, sir, it is of 11th March 2020, lordship.
Yes.
Sri Manavendra Chakraborty is hereby offered engagement as consultant, principal private secretary in the regional bench Guwahati under Rule 194, Clause 4 of GFR, that is General Financial Rule, lordship, for a period of 6 months with effect from the date of joins of duty as consultant TPS, but in any case not later than 20 March so and so. The conditions are laid down below, lordship.
Yes.
The first, may I read the conditions, lordship?
Yes.
That he shall be paid consolidated and fixed remuneration of rupees 60,000 per month and shall not be entitled to other requisites. That during the period of engagement, he will be entitled to 1 day's paid leave for each completed month. In case of leave in excess of 1 day per month, deduction on pro rata basis would be made from the lump sum contractual amount payable to him. That his engagement as consultant in Armed Forces Tribunal Regional Bench Guwahati shall be subject to satisfactory performance and can be terminated without assigning any reason whatsoever. That his engagement will be on full-time basis and he will be required to attend the office on all working days and also on holidays if required on account of exigency of work for which no additional remuneration will be paid. Then E, that the income tax or the other liable to be or tax liable to be deducted as per prevalent rules will be deducted at source before effecting the payment for which the department will issue TDS certificate. F, that the appointment shall stand terminated automatically without any specific order to that effect on completion of terms of engagement, and if the day of expiry engagement happens to be a holiday, the engagement shall stand terminated a day before. Z, lordship. That 1 month's notice has to be given or an amount of equal to 1 month's remuneration has to be deposited by him if he wishes to terminate the engagement immediately. Lordship, this is important. That he will have to give lordship 1 month's notice if he wants to quit the job, lordship. So that binding has been put to him. But subsequently, now without, this is the employer is lordship the principal bench. After subsequently, his contract has been continued up each and every 6 months, after 6 months, and till today he is continuing with this only. That but subsequently his remuneration was enhanced from 60,000 to 80,000 also, lordship. But lordship, from June till June 2024, he received at a rate of 80,000. But suddenly, lordship, the area accounts office, Shillong, they have reduced the salary from 80,000 to 26,270. The impugn order, lordship.
80,000 is his remuneration was 60,000.
60,000. Subsequently, it has been enhanced at lordship. It is at page 29. Page 29. From 2022. May I read, lordship? Yes. The Honorable Chairperson has been pleased to fix the enhanced consolidated monthly remuneration with effect from 1st May 2022 in respect of the following categories of consultants. Deputy Registrar or equivalent, rupees 80,000. The PPS consultant is equivalent to Deputy Registrar. And after this enhancement, he has been continued to be paid 80,000 only. And lordship, this is very important that this copy was this enhancement was marked to the copy to was made to Principal IFA, that is Principal Integrated Financial Advisor, Kashmirios. This is the from Finance Department, Government of India, Lordship. Then second is Pay and Accounts Office, MOD, Ministry of Defense, first floor, New Delhi. Accounts Office. So all were informed. They had no complaint. But suddenly the impugn order, Lordship, at page 40, they have reduced it, showing some, Lordship, the notification of Ministry of Finance, Lordship, DOPT, Lordship, not Finance, page 40. May I read, Lordship, that page 40?
Yes.
Its subject is reduction of fixed remuneration of consultants appointed in AFT regional bench, Guwahati by Area Accounts Office, Shillong. So, Lordship, reference AFT so and so. With reference to the above, it is intimated that this office has regularized the remuneration of both the consultants as per Department of Expenditure, Ministry of Finance, OM number so and so, dated 9/12/2020, and headquarters office letter number so and so, dated 26/3/24. According to the EBID OM, monthly remuneration of consultant appointed on contract basis would be arrived by deducting the basic pension from last pay drawn at the time of retirement. This office has called for the documents from AFT Vice so and so, dated 8/54, and so and so. And after receiving all the documents, this office has regularized the remuneration of the board consultants as follows. So Manavendra Chakraborty's name is at serial number 1. His, Lordship, the second last column, basic pension is this, and the final remuneration has been reduced to, Lordship, it is 26,270, the last column. And it is very interesting, Lordship. There are 11 armed forces tribunals throughout the India. Only this area accounts office has only by selectively targeted us, these two persons, and reduced it. But till today, all the other, though there is no intelligible difference between all the other employees, they have been receiving the remuneration fixed by the appointment in terms of the appointment and the guidelines, Lordship. And for the in violation of natural justice, nothing notice, nothing has been given to him. And during the pendency of this petition, Lordship, the petitioner's engagement has been Lordship, again extended with the remuneration of 80,000, but they are not paying it. The last, Lordship, enhancement order is with me, Lordship. It is with again 80,000. This is the, Lordship, during the pendency. All other benches, they have been paid. This is the last enhancement. And now he's still continuing. Lordship, the appointing authority has also filed their affidavit. They have said that nothing irregularity has been done. In their affidavit, Lordship,
Nothing.
No irregularity has been done because it has been done as per the provisions of law. Their appointment has been done as per the provisions of their remuneration has been fixed as per the provisions of law. In their affidavit, they have annexed the gazette notification also. And in terms of the Armed Forces Tribunal, Lordship, Armed Forces Tribunal Financial and Administrative Powers Rules 2008. Section 4 says powers of the chairperson. It speaks about, it says, Lordship, the chairperson shall have the same powers as are conferred on a department of central government. In my affidavit, I have categorically stated that also, Lordship. The chair, may I read once again, Lordship? The chairperson shall have the same powers as are.
You are reading from which page?
Lordship, affidavit is their affidavit.
Their affidavit filed in 4972.
Yes, 4972 filed by the principal bench, Lordship. The employer, Lordship. They have annexed it. At page 60 is the gazette of negative notification. Page
Yes.
60. section 4. Page 61 is the section on last page. The chairperson, Lordship got it.
Hmm. Page 60.
61 is the relevant section 4.
There is no 61 in this affidavit. 61 is the affidavit in reply. Just give it to him.
61 is written. It is there, Philip. Otherwise also, yeah. Otherwise,
Otherwise, we'll go later. Where
Yes.
is your page 61?
yes, Lordship, it is there. It is there in Mudak 61. 67, 45.
Hmm. What do you want to show from here?
As section 4, the power of the chairperson, Lordship. This is the power of the chairperson, section 4, Lordship, got it.
Hmm.
It says the chairperson shall have the same powers as are conferred on a department of the central government in respect of delegation of financial powers rules 1978, the general financial rules 1963, the fundamental and supplementary rules, the central civil services leave rules, etc. So and so, Lordship. So, Lordship, the chairperson has got the financial powers. It's a AFT's chairperson has got the financial powers as that of the central government departments, other departments. In terms of that, Lordship may again come to the appointment order.
No. Please read further. Read
Further,
further.
yes, provided. Yes, Lordship. Provided that the exercise of financial powers shall be subject to any procedural or other instructions issued from time to time by the government and after obtaining the advice of financial advisor and chief accounts officer of the tribunal. Provided further that in respect of the matters not within the competence of the chairperson, concurrence of the Ministry of Finance or any other authority shall be obtained by chairperson through Ministry of Defence. So all has been taken care of in their affidavit. They have said they have taken the concurrence of the principal integrated financial advisor. I have also in my affidavit, I have categorically stated that, Lordship. After doing this, after following everything, the remuneration was fixed and paid since 2020 to 2024, which he accepted, Lordship. But in other benches, they are continuing. Till now, the reason they are saying that the notification. Now, Lordship may come to the
Other
notification.
bench continue with what?
With the remuneration, that is 80,000 and the 48,000 in case of the other petitioner.
Where can one find it?
Yep, I have made the statement, Lordship. They have not denied in their affidavit also. That they are in my
Where is that
paragraph 7. Paragraph 7 and paragraph 12.
No, but what basis you are making this statement? Paragraph 7.
Lordship. Paragraph 7.
Hmm.
May I
Read
read
it.
that? That the petitioner begs to state that he has been receiving remuneration fixed by the authorities at the time of granting extension of his engagement without any complaint from any quarter till month of June 2024. But to the shock and surprise of the petitioner, his consolidated remuneration from the month of July 2024 has been reduced by the area accounts office to rupees 26,270 from rupees 80,000 fixed at the time of his engagement, in violation of the guidelines and procedures for engagement of consultants in Armed Forces Tribunal, framed in exercise of powers conferred under Rule 179 of the General Financial Rules 2017. Wherein, in addition to the procedure for selection, contraction, and monitoring of consultants, the consolidated monthly remuneration payable to the consultants engaged has also been mentioned. Now it is pertinent to mention here in that there are in total 11 numbers of Armed Forces Tribunal benches throughout the nation, including the principal bench at New Delhi. And all the consultants engaged in these benches are receiving their monthly remuneration in terms of their letter of engagement issued in accordance with the guidelines and procedures for engagement of consultants in Armed Forces Tribunal without any interference from any quarter till date. But the respondent number 5 has illegally and arbitrarily reduced the monthly remuneration of the petitioner fixed by the competent authority. And paragraph 12 also, Lordship. paragraph 12, Lordship. Page 14. So, Lordship, that the petitioner begs to state that he was receiving his monthly consolidated remuneration till June 2024 at par with his counterparts engaged in all other 10 benches of the AFT, but the respondent has unilaterally and selectively reduced the remuneration of the petitioner by applying OM dated so and so, dated 9/12/2020, and headquarters dated 26/3/24, which amounts to causing discrimination amongst the equal. There is no intelligible difference between the consultants engaged in all other 10 regional benches of the Armed Forces Tribunal to that of the petitioner, and as such, there cannot be any difference in monthly remuneration between the remunerated employees that of the petitioner.
All right, now where are the guidelines and procedure for engagement? Of
Yes,
consult-
guideline, I have annexed it, Lordship.
Yes,
Guidelines is at page 24. Annex D. May I read, Lordship?
Hmm. Yes,
Yes. Guidelines and procedure for engagement of consultants in the Armed Forces Tribunal. With a view to bring about transparency and uniformity in the matter of engagement of retired government servants as consultants in the Armed Forces Tribunal in exercise of the powers conferred under Rule 179 of the General Financial Rules 2017, the tribunal thereby makes the following guidelines for regulating the method of engagement of consultants in the tribunal. The purpose is that is given. The purpose of these guidelines is to define the broad policies and procedures for selection, contracting, and monitoring of consultants from the resources of the tribunal. Then 1.2, for the purpose of these guidelines, the term consultants includes retired government servants from central government, state governments, Supreme Court, high courts, district courts, or statutory authority bodies. And Lordship may come to the definition. Two definition, it says, for the purpose of these guidelines, unless and context otherwise requires, A, the tribunal shall be include the principal and its regional benches. 2, the competent authority means the honorable chairperson of the tribunal. Then the financial advisor means the principal integrated financial advisor. So and at the time of enhancement also, we have sent copy to
so your client is holding
Consultant.
a office of registrar or equivalent.
Lordship, register, or it is a register or equivalent, Lordship.
What is the, he is now a consultant, what? What is it?
Consultant PPS, Principal Private Secretary.
Consultant PPS is registrar or equivalent?
Yes, as per the.
Where can one find it?
Lordship, it is, there is no such the guideline with me, Lordship, but it is, they are paying with, they have not denied it, that it is not.
And what is the other writ petitioner, JAO, that is equivalent to which post?
Yeah, equivalent to Lordship, he is equivalent to. Lordship, I am kidding. He is equivalent to Lordship, Assistant Tribunal Master. It is in the writ petition, Lordship, 5517/2024 at page
No,
30.
no, I am asking you, in that guideline,
Lordship.
the writ petitioner in the first writ petition, his post according to his equivalent to registrar or equivalent.
Yes, Lordship, yes.
What about the second writ petition?
Second, Lordship, he is assistant tribunal, assistant/tribunal master or equivalent. His salary is 48,000. But here, no 48,000 has been shown here. In this letter of 21st, in this letter of Lordship Annexure E, in the letter of 21st June 22. But subsequently, in Lordship 16 January 23, which I have annexed in the next writ petition, it is stated that the assistant/tribunal master or equivalent is equivalent to JAO, that is Junior Accounts Officer Consultant, with 48,000 remuneration. It is in the next writ petition I have annexed. That is subsequent to this of 22's letter. So Lordship, since I am continuing, if something comes in after my Lordship cancellation, they may do that. In between, Lordship, I have accepted the everything after going through it. I have been allowed to continue by the employer. They have come in. and they're putting in the notification of 2020, saying that no, you are not entitled, we are reducing it. Lordship, they may do it. There is nothing. If it's as per law, they may do it. On the other one hand, they are paying out to all the, and selectively they are reducing our pay. And during the continuance of the work, which I have accepted also.
So what is the reply to para 7?
They have not, they have their mum. They said nothing, Lordship. Para 7. In their affidavit, Lordship, it starts from. They are just saying that the 2020 notification is applicable, so they have reduced it. Nothing clarification.
2020?
That notification in terms of which they have reduced it.
When is the notification?
Its notification is at page 50 of the affidavit filed by the respondent, Lordship. 50. The DOPT guideline, Lordship. Page 50. And
Yes.
the remuneration 6 is the remuneration.
Page 51.
51, 6, remuneration. Section 6.
Yes.
Section 6, may I read? Remuneration. A fixed monthly amount shall be admissible, arrived at by deducting the basic pension from the pay drawn at the time of retirement. The amount of remuneration so fixed shall remain unchanged for the term of the contract. There will be no annual increment / percentage increase during the contract period. On the basis of this, they have reduced it. And they have also relied on section 12, section 10, page 52.
So according to them, you are entitled to total of 80,000, which is inclusive of your pension. Is that the stand?
No, yeah, according to the employer.
Yes.
Yes, Lordship. According to the employer.
Mr. Tavidan, listen to the query. You are in a hurry. You want to go somewhere.
No, Lordship.
You seem to be in a great hurry.
No, Lordship. No.
Hurry will bury
Yes,
your
Lordship.
case.
Yes, Lordship.
Their stand is that the amount of 80,000 which your client is entitled to
Yes, receiving.
Lordship,
Lordship.
is inclusive of the pension amount which he is getting for his previous service. Is it their stand?
Yes, that's
Is that their stand?
No, according to us, the basic pension which he has drawn at the time of retirement, after deducting what will be, that is, he is eligible for that much amount.
No, but that amount you will calculate with reference to what?
Our case is that once whatever amount
So
is paid,
after deducting his pension,
Yes.
you pay him 80,000. Why you will not pay him? You are not understanding simple questions. I am asking, is it your case that the total amount he is liable to receive is 80,000? So since his pension is this, the balance is this. Is that your stand?
yes,
Huh?
yes, we have to deduct his pension amount from 80,000. That much he will receive.
Under what authority you are doing it? And what is your stand? He's saying that all others are receiving. You have not denied.
He had not that is a statement, and we have denied that being matters of record. We have stated in our affidavit that well, whichever is not correct, we are denied that. Although specifically in paragraphs in reply to paragraph 7 at page 44, Lordship, I have stated that
There is no clarity in your. This notification
Lordship,
guideline at page 24.
Lordship.
This lays down the amount to be paid to the consultant registers, correct? So read petitioner, the first read petition is the consultant register level post. That you agree? There's no dispute about that.
No.
So he is entitled to 80,000, right? And that is the amount which was originally given to him. And subsequently also he has been given that.
Lordship.
In between, suddenly why it has been
In
changed?
fact, Lordship, it has to be deducted at the very initial stage only, Lordship, but that was not deducted. Subsequently, this memorandum, one notification, after this notification, page 53, Lordship, this is of 26/3/2024, when government had issued this, that although it's some different views were differently they were paid. So this page 53. This is, we have given to all the Controller General of Defense Account had given this to all the Armed Forces Tribunal, that you have to follow this notification of 2020 and payment has to be made in terms of that clause, Lordship. And thereafter, these deductions were made. In fact, the notifications was from 2020, but somehow it was not followed
So
unilaterally.
now the 80,000 is what they will get, plus pension.
No,
Then
80,000 is amount as per this, but after deducting the pension, he will get. If someone's pension is 30,000, he will get 50. If someone is 40,000, he will get 40. So that is what our stand is. After deducting his last monthly payment as per this clause 6, Lordship.
where is that provision? That's what I'm asking.
This guideline office memorandum is 6, Lordship, page 51, remuneration. This office memorandum is of 9 December 2020. Page 51, remuneration, a fixed monthly amount shall be admissible, arrived at by deducting the basic pension from the pay drawn at the time of retirement.
Which page you're reading from which page?
Page 51.
Hmm.
Remuneration. A fixed monthly amount shall be admissible, arrived at by deducting the basic pension from the pay drawn at the time of retirement. The amount of remuneration so fixed shall remain unchanged for the term of the contract. There shall be no annual increment or percentage increase during the contract period.
So where have you mentioned it in his appointment order? That your remuneration.
That appointment was made by respondent number 4, Lordship. Respondent number 4 have not followed this rule, Lordship.
Then you have
Sorry,
initially it was.
respondent number 2. Respondent number 2. I am for 1, 4, and 5. So respondent number 4 have not followed these rules. Subsequently, they this 2024 of later we have also issued 26/3/2024 Annexure B.
No, there seems to be a needless complicacy created in this matter. See, first, his appointment is of 11th March 2020. That is a contractual appointment. So the terms and conditions will be governed by the contract. So his terms and condition of appointment says you will be paid a consolidated and fixed remuneration of 60,000. There is no mention of any deduction, adjustment, nothing. Then this 60,000 has been enhanced to 80,000.
Not.
When was it enhanced? Which is that is in
Lordship,
page
page 30, page 29, Lordship.
In fact, there is no amount as 60,000
But enhanced.
initially.
You will be paid that's your internal matter. We are only concerned about what is there in the contract and terms. If you given him 1,80,000, you will have to pay him that. What is your rules and guidelines is your matter. It doesn't make sense. Then you said on 23rd of June 2022, you said you will be paid a consolidated fixed remuneration of 80,000. So that is the terms of appointment. Correct.
Page 34 is clear, Lordship. 34 is also there. Page 34. It will make clear, Lordship. Subsequent engagement. Clause A, 80,000.
So 28 June 2024, again, you say that you will be paid consolidated and fixed remuneration of 80,000 per month and shall not be entitled to any other perquisite. So where have you mentioned that this 80,000 will be after adjusting your pension?
That is not mentioned by the appointing authority, but he has to follow these rules, Lordship.
Take action against him. What is the interest you will pay him? Just tell us that. 12% or 18%.
But he cannot supersede
That is
this
you go
notification,
and
Lordship.
take action against him.
And because, Lordship, this rule also, I have
That is
quoted
your internal matter.
one more thing. That we have also quoted that this financial page, I have last page, Lordship, that General Financial Rule, clause 6(2), page 60. The system and procedure established by these rules may be modified by any other authority only with the express approval of the Ministry of Finance. So those are the Ministry of Finance notification. So when initially in the year 2020, the notification was not there because the notification came in the later part of 2020, and first appointment was in the initial part of 2020. But when this notification came, Lordship, so subsequent contract, he has to follow this notification, the appointing authority, which were not followed, Lordship.
Nothing. Only thing that will be binding on him is the terms and conditions of contract.
Because their terms and conditions were not permanent, Lordship. It's for 6 months. Then they have renewed it. But for renewal part, Lordship, he has to follow these notifications because
No, he doesn't have.
this 16/3/24 and
These
9.
are your internal matter. You have given him a appointment order by mentioning the terms and conditions. 60,000, 80,000, 90,000, that is your prerogative. Once you have named the figure as a fixed consolidated pay and no other amount will be payable, he joins. Then you say that your salary is 80,000, but you will get 20,000 because we'll deduct 60,000 of pension. What kind of a stand is this of a Government of India department? I'm sorry, we'll have to make some scathing observations.
Because, Lordship,
We'll pass some strictures in these matters.
respondent number 2 and 3 had not followed those
No,
rules,
we
Lordship.
mentioned that this is not befitting of functioning of a central government department. There is
Okay.
something seriously wrong.
Lordship, Rule 6(2) of General
Whatever rule, you corrected, you should have then told him that we'll give you 20,000 as salary. What is this camouflaging kind of?
In fact, Lordship, 2 and 3 had exceeded their power, Lordship. They must have followed these rules.
Take action
Lordship.
against them. You can't take anything away from these officers.
Because General Financial Rule 6(2) of that I have shown, Lordship, is very clear that he has to follow the Ministry of Finance guidelines. So Ministry of Finance first initial appointment, that notification was not there, but in the year month December 2020 that came. So he has to thereafter he has to follow that. And then also it was not followed. We have given this 2024 letter to the armed tribunal also, but that was also not followed, Lordship.
You are engaging a person on a fixed remuneration. How does it matter to you what he is getting as pension? Then you have to give him full salary minus the pension. That you are not giving him. This is a contractual appointment on a fixed remuneration. How are you bothered what he is drawing as pension?
Because it's in the no.
All right,
Notification.
we'll read down the rule. Anything else? Allowing the writ petition. We don't have any
That
case.
notification and
You are
then
appearing for respond number?
1, 4, and 5.
And what about you, Ms. Ram? Yes. What is your stand?
My stand is as per Gazette notification, that is page number 67, my lord. Chairperson,
Yes.
Chairperson, my lord, section 4, my lord. Chairperson shall have the same power same power as are conferred on a department of the central government in respect of delegation of the financial power rule so and so and so and so. Provided that the exercise of the financial power shall be subject to any procedure or any other instruction issued from time to time by the government after obtaining the advice of the finance advisor and chief account officer of the tribunal. For both the petitioner, my lord, we have already obtained that approval from the finance department also, my lord.
Approval for what?
For the salary, my lord. One is for what comes to my current salary.
Approval to pay 80,000.
80,000. And in for that also, my lord, before giving that, we have taken the approval from the finance department also, AFT, my lord. Chairperson has taken that, my lord.
May I point out one thing, Lordship? At the time of enhancement, Lordship, everything was made known to the finance department as well as
Yes.
Ministry of Defense at page 29. I have pointed out earlier.
Hmm.
Annexer E.
Then
Lord.
why she is taking this stand? This is contrary to the record.
Annexer E. Lordship. Annexer C copy to Lordship, page 29 of the this petition.
1 minute, 1 minute. This notification in page 40, who has issued this?
Page 40. This is issued by the area accounts office. They were not a party to the contract also. Area accounts office.
Area accounts officer?
Shillong. Lordship area accounts office in the headline is
That is respond number?
is a respondent number Lordship 4 and 5. Respondent number 5. Deputy Controller of Defense Accounts, area accounts office. And copy was sent to them also. Pay and accounts office, Ministry of Defense. That at page 29.
Yes.
So this guideline says 60,000. It was then enhanced to 80,000.
Lordship.
Yes, madam.
Where is that 80 enhanced?
It is at page 29.
Page?
29, Lordship.
So you were paid 80,000 up to the month of June 2022.
24.
24.
24. And now I am also continuing, but in the reduced amount, though I am continuing, and engagement has been given for 80,000 only, but they are not paying it.
But you are drawing how much now?
Now 26,270. Reduced to 26,270 from July 2024.
And that is on the basis of this.
Notification of 29, 19, 12. It is at page 50 on 9th December 2020.
At page 50.
50. This is the notification.
No, where is the.
Impugned is at page 40. 40. Last column. Final remuneration arrived.
So then also, how does it measure 26,000 plus 46,300? That is his pension. 46,331 is his pension.
340, not 340, 31.
40 is his pension.
Lordship, that has been reduced. The calculation part has been done by them, Lordship. That was my number.
And final
180.
remuneration arrived.
Yes, 26,270. Now I am getting this amount.
So how this amount, this is not even 80,000.
Lordship, they have done it. I don't, that part, calculation part has been done by
Yes,
them.
Ms. Sharma, even let us assume for a minute that your stand is correct. How have you arrived at this figure? Hmm? How have you arrived at this figure of 26,270?
Lordship, 46,340 minus 20,070, Lordship.
Hmm. Please, I'll ask you one more time because this is relevant to fix how much of interest the department will pay him. Only on that count we are asking this question. It could be 12%, 18%, anything to be recovered from the salary of erring officials. That's the order we'll pass. So you have to tell us how even if your version is to be taken to be correct, how have you arrived at this figure of 26,270? Because when you pass this order, the amount payable according to your own showing is 80,000. So if you minus 46,340 from 80,000, how do you get the figure of 26,270?
Last basic pay 18,880 and his grade pay is 5,900, Lordship. And as per this notification, this pays 51 fixed monthly amount shall be admissible arrived at by deducting the basic pension from the pay drawn at the time of retirement. So his basic pension is 20,070 and his last basic pension from the pay drawn at the time of retirement. So his pay drawn was 46,340. At so from 46,000, that is his pay and that is his pension. So from the pension pay, his pension has to be deducted as per the notification. That is what in the notification.
Correct, but how have we arrived at the figure?
80,000, Lordship.
The only question is whether it will be 12% or 18% per annum interest. That's why I'm asking. The amount of malice must be equivalent to the amount of interest proportionately, is it not?
But Lordship, this page 53 is also clear that this they have the right, but not after this notification that PC clause 4, page 53, that they have shown that they have intimated the authorities PC and DA and CSDA, Controller Defense Accounts, that accordingly clause 4 of page 53, so and so may admit pay and allowance as per terms of condition of the contract entered into by the AFT employees. It would apply to contracts concluded prior to issuance of the later dated 9/12/2020. So after 9/12/2020, remuneration has to be as per this notification, Lordship, which is Ministry of Finance.
No, but they
guidelines.
have obtained approval.
But this approval only they have to follow this rule after 9/12.
2021, the approval is there.
Because 9/12, this letter of 26/3/24 also says that after this notification, 9/12/2020,
Hmm.
they has to follow this.
This approval is by whom?
My lord, select B, my lord.
Hmm.
That means from select B, my lord. issue with approval of PRIFA. PRIFA is Principal Integrated Financial Advisor. Clause 3, my lord.
Yeah, but where is the approval for the petitioner in this case?
My lord, kindly say, in flag A, my lord,
Hmm.
2B, approval of CFA has also been obtained, my lord.
No, this is,
This
flag
is-
A is regarding whom?
Regarding, my lord, Manavendra Chakraborty. Yes, my lord, this is present petitioner, my lord. He said this one. Statement is there also, my lord, in.
In flag A, who is the authority who has given the approval?
Flag A, my lord. Approval of CFA has been obtained. Take for a moment.
You want this back?
Yes, for a
Yes.
moment, my lord, I'm giving.
Correct. Yes. लिखिबो हाँ read petition 4972 of 2024. Take down. Heard Mr. A.R. Tahbildar, Learned Counsel, appearing for the writ petitioner. Also heard Ms. B. Sharma, Learned CGC, representing the respondent numbers 1, 4, and 5. Ms. A. Gayan, Learned CGC, has appeared on behalf of respondent numbers 2 and 3. Stop. The basic controversy involved in this writ petition is pertaining to the reduction stroke refixing of the petitioner's remuneration at rupees 26,270 by reducing the same from the fixed remuneration of rupees 80,000 as per the terms and conditions of his contractual agreement by relying upon a provision, by relying upon purportedly by relying upon the regulation of remuneration in case of contract appointment of retired central government employee dated notified on 9/12/2020. Acha, upor likhibo, the writ petitioner herein is a retired government employee and presently is in contractual appointment under the Armed Forces Tribunal bracket regional bench
Regiments, Guwahati.
bracket close at Guwahati as consultant
Yes, bracket,
PPS
bracket PPS.
bracket PPS. Full stop. the petitioner is aggrieved as per the terms and conditions of the contract. The fixed remuneration payable to the petitioner is rupees 80,000. However, in purported compliance of the guideline so guideline notified wide OM dated 9/12/2020, the respondents have reduced his monthly remuneration to a mere sum of rupees 26,270. Hence this writ petition. Stop. The facts and circumstances giving rise to the filing of this writ petition may be noticed herein below. Briefly noticed herein below. Full stop. The writ petitioner was an employee of the Guwahati High Court, and on attaining the age of superannuation, he had retired from service with effect from.
Retired from service with great lordship. I have not
Actually,
mentioned.
your petition should be dismissed for not disclosing anything.
No, lordship, I have mentioned it. That is,
You have not said when was the advertisement made. Nothing has been mentioned.
advertisement is not there, lordship.
Then
Advertisement is not there. Retired from, and he joined, I have written in paragraph 3. Paragraph 3, lordship, I have given. Date of retirement, superannuation not mentioned.
in attaining the age of superannuation with effect from.
With effect from, I have not mentioned. I'll give lordship.
Go and find out after Bihu.
Lordship.
After Bihu.
I'm sorry, lordship.
No, you can be sorry. I'm accepting your sorry. But what can be done? I cannot write a judgment in this kind of a petition. You don't have any responsibility. We have.
Sorry, I
What kind
understand,
of a
lordship.
petition is this? On the prayer of Mr. Tawilda and the council for the petition.
I'm sorry, lordship.
Again in the next week as a fixed part item along with WPC so and so. Yes, I'm also sorry. Make a complete note. When did he retire? What was the pension? When was this advertisement issued?
Yes,
Then every details you give it. Come up with a separate note.
lordship.
Is keep it there with the file out.
You keep it with yourself because he may not be ready even in the next date.
Lordship,
Poor state of affairs, Mr. Taibilda. I expected it to
advertisement
be-
was not there, lordship, because
All right, but you don't even know when he retired.
date of retirement. I
Ah. All right. Next week.
obliged, lordship.
I would have written this judgment
Yes, lordship,
today.
I'm very
Next
sorry.
week, I'll make it reserve and deliver the judgment in August. And you are responsible for that.
May I please your lordship? Lordship, I am apologized to say that as per order dated, last order dated, I could not file due to some technical difficulties. I could not file affidavit, lordship. Lordship, I have filed today, lordship.
You filed affidavit today.
Yes, lordship.
You are appearing for?
For respondent number.
Fee is not yet
for-
served to me.
Lordship, he denied to accept.
No,
account because
while
of
item
this
number 5 was continuing, he
Just a
approached me.
minute, just a minute. What is this matter about?
But the matter here is petitioner is the senior most professor of homeopathic college. And he was expecting for the post of vice principal, but instead of appointing him, promoting him to the post of vice principal, respondent number 4, who is not eligible for that, he is a reader, and he has been appointed, my lord. And the department has, government has filed affidavit. In their affidavit, they have stated that National Council of Homeopathy Regulation is silent about vice principal post. So they prepared a panel considering the eligibility criteria of principal. But if that be so, my lord, then also respondent number 4 is not eligible as per the regulations. Because there was earlier 2013 regulation, as per 2013 regulation.
All right, so now they've filed a counter affidavit. You have received the copy?
No,
not lordship.
Yet not filed.
No,
Yet not
lordship,
filed.
I
Last
not
occasion
filed
was
it.
last Sun's, and last occasion, when a senior council prayed,
No,
accordingly it
Lordship,
was.
what happened? I have given his copy, but he denied to accept.
No, while item number 5 was continuing, she approached me, then I requested her, let the matter come and file.
Take it, we'll have it next Thursday.
Mal.
If it
Next-
is, if it is filed today, then only, otherwise it
Lordship.
will not be taken on record. Heard Mr. K. M. Halil, Learned Counsel for the petitioner, also heard Ms. R. Kakati, Learned Counsel, appearing for the respondent number 4, who submits that a counter affidavit on behalf of our client is being filed today during the course of the day, and therefore the matter be posted again in the next week. Mr. You are appearing for? For the petition. Mr. K. M. Halil, Learned Counsel for the petitioner has expressed urgency in the matter and has requested the court list this case again on next Thursday, date month. P4.
Mal.
A prayer allowed, registered to list this case again on 3/4/2025, along with the counter affidavit for the respondent number 4. If the same is brought on, if the same is filed during the course of the day.
Macho.
Only if the same is filed during the course of the day.
For hearing, I
Well, page 52 में contribution. While he was serving as the head assistant, my lord, this penalty was imposed without following the service rule, rule 9 particularly. No show cause, no charge sheet, no evidence.
This is an order of penalty.
Yes. And against this, my lord, we have filed appeal saying that, my lord, no procedure of rule 9 was not followed. No charge sheet was given, no inquiry report is there. So after that, my lord, they have passed this order at page 61. 59. Page 59. Operative part is at page 61. However, considering his second paragraph, considering CD Roy's submission that his indisciplined, rude behavior were unintentional, that he has only 4 years left to retirement, that he will not repeat the undesired behavior and action, that he will work with the desired commitment, relying on good faith, it is decided to limit the action on him to the following: censure, treating his period of suspension from 19/5/2020 to 26/7/2020 as leave as per revised leave rules adjustable from the available leave at his credit as per revised leave rule 1934. Now this, without charge sheet, I have stated in paragraph 18.
So the other penalty has been interfered with.
Only one penalty from reduction of his rank.
That has
from
been
head assistant.
interfered with.
That has been.
Censure, there is no requirement of any.
No, that I'm coming, my lord. That your lordship, other day I think I convinced your lordship. Today your lordship has forgotten. I'll bring it, my lord.
We keep forgetting, Mr.
That's what.
Only some things we remember, others we forget.
My lord, what I pray, my lord, your lordship will kindly say another paragraph. Pay paragraph 18.
Paragraph 18.
18.
Paragraph 18 of your
My writ petition.
petition.
Respectfully submits that the action on the part of the respondent authority in issuing the impugn order is expressly arbitrary and in violation of provision of law, inasmuch as the penalty of censure and treating the period of suspension from so and so as leave as per the revised leave rule is expressly arbitrary and in violation of provision, inasmuch as the penalty was imposed without giving charge sheet and without giving any opportunity to cross-examine any of the witnesses, if any, and the same is in complete violation of rule 9. So their reply, your lordship will kindly see what their reply is. That your lordship will get it at page 91.
No, Mr. Das, You place your case and you argue, there is no difficulty. I am only asking you one question
My lord,
to understand the legal intricacies.
yes,
Your client was initially subjected to an order of penalty, which has got two penalties, a minor penalty and a major penalty. Minor penalty is of censure and major penalty was a reduction of his rank. The
And-
word used is post, but that's wrong. It should be ranked and downgrading his pay structure also. You prefer an appeal before the appellate authority saying that this penalty has been imposed without complying with the provisions of Assam
rule 9.
Service Rule 9 of Assam. In the sense that no inquiry held, no charge sheet submitted.
Right.
The appellate authority accepted your plea and for whatever reason mentioned there, 4 years left for retirement, etc. The penalty of reduction of rank, etc. has been interfered with. So what remains is censure.
Censure and treating the period of suspension
Treating the period of suspension as
as leave to
right,
his credit.
right. Mhm.
Both this cannot be done because my lord censure, my lord, your lordship will kindly see, I will take your lordship to rule 9.
Rule 9. Let us see rule 9.
Yes. And I'll place two judgments.
Yes.
Judgments are there. C and D. I'll provide. This is fundamental.
Rule 9, which part you want to show?
My lord, Rule 9(11), my lord.
Yes.
If the disciplinary authority having regard to its finding on the charges, charges, your lordship will kindly see, is of the opinion that any of the penalties specified in clause 1 to 3, censure comes in, of rule 7 should be imposed, it shall pass appropriate orders, and in every case in which it is necessary to consult the commission shall do so after consulting the commission. This is charges, on the basis of the charges. You have not framed any charges. So
Please read the
now-
next one. Next.
Yes, next one is 12A, 12A. Notwithstanding anything contained in this rule, it shall not be necessary to follow the procedure laid down in the preceding sub-rules in cases where it appears to the authority competent to impose the penalty at the initial stage. At the initial stage, my lord, of the proceedings, that the penalty of censure would be adequate. But if any later stage, it is proposed to impose any other penalty, specified in rules, the procedure laid down in the said rules shall be followed. Now, 12B, your lordship will kindly see, 12A, 12B. No order imposing the penalty of censure shall, however, be passed except after the government servant is informed in writing of the proposal to take action against him and of the allegations on which it is proposed to be taken, and given an opportunity to make any representation he may wish to make. So in the present case, my lord, in the present case, my lord, the charges have not been framed. And before the framing of the charges,
No,
if you
charge
want to
is
do
not required,
something-
but was anything, any written communication issue?
Nothing.
That you are guilty of so
No,
and
no,
so, so
nothing
nothing.
is there.
Straight
So
away that
therefore-
order has been passed.
Yeah, on the basis, no, I mean, my lord, before the initiation of the, and not only this order, reduction of rank, then treating the period of suspension, my lord, these three orders was passed. These three orders were passed without following rule 9. So therefore we file appeal. If they would not have, my lord, given, only the censure could have been given on the basis of without drawing charges. That is the provision of law, what I understand. Only the censure can be given, but other penalties like, my lord, reduction of rank and treating the period of suspension in different way, it cannot be
So
done.
your client is still in service?
Now, my client is in service. Client is in service. Now, two decisions I have placed. This is, my lord, one by division bench, another by justice. My lord, another provision I better placed now, 54, FR 54B, 1B, that is regarding treating of the.
FR 54 1B.
No, 54B, my lord, 1B. Then 5 and 7, my lord. When a government servant who has been suspended is reinstated or would have been so reinstated but for his retirement or superannuation, the authority competent to order reinstatement shall consider and make a specific order, whether or not the said period shall be B, my lord, to be treated as a period spent on duty. Now,
No, 1 minute. You're reading from FR 54.
B, my lord, capital B.
All right. Yes.
Then 5, your lordship will come to.
Then next is
5, same, my lord. Sub-rule 5. In
Yes.
cases other than those falling under sub-rule 2 and 3, the government servant shall, subject to the provisions of sub-rule 8 and 9, be paid portions of the full pay and allowances to which he would have been entitled had he not been suspended, as the competent authority may determine after giving notice to the government servant of the quantum proposed and after considering the representation, if any, submitted by him in that connection within such period, which in no case shall exceed 60 days counted date of notice. So therefore, my lord, and in 7, your lords, you can see, in a case falling under sub-rule 5, the period of suspension shall not be treated as period spent on duty unless the competent authority specifically directs that it shall be treated for any specific purpose, provided that if the government servant so desires, such authority may order that the period of suspension shall be converted into leave of any kind, due and admissible to the government servant. So all this thing has to be done after giving a notice to him. My lord, C and D, my lord. So in regard to, my lord, one that regarding FRSR, your lordship will kindly take into consideration the Central Administrative Tribunal's, my lord, this order was passed by Honorable Justice D. Pathak. The provision has been explained. That Central Administrative Tribunal's order, listening.
the two judgments have been given.
Two judgments, and earlier I had given.
One is Jamaluddin Lashkar and other is Samaresh Chandra Bhattacharya.
Yes, Jamaluddin Lashkar, your lordship will kindly see, is a small judgment by Justice Roy. The petitioner is I can read paragraph 2. Petitioner is the headmaster of so and so school in Kachar district, and the challenge is here is the order dated so and so, whereby the penalty of dropping one annual increment was imposed on the delinquent under Rule 7. That is the minor penalty was imposed. Assailing the impugned order, the petitioner contended that the charges were not framed. Paragraph 3.2, an inquiry was never conducted. That was the case here also, madam. To facilitate the delinquent to defend the charges, and accordingly it is argued that the petitioner was penalized without the opportunity to rebut the charges. Now, paragraph 7, your lordship will kindly see. However, what emerges from the inquiry report annexed to the counter affidavit filed by the D is that the conclusions were drawn only on the basis of the response given by the delinquent, same in this case, to the show cause notice dated so and so, but formal inquiry was never conducted into the charges. In fact, the impugned punishment order dated so and so does not refer to any inquiry finding. When any of the penalties specified in Rule 7 of the Disciplinary rules are to be given, inflicted, the procedure for imposing penalties are laid down in Rule 9 of the discipline rules. But the elaborate procedure for conducting the inquiry prescribed by Rule 9 was wholly overlooked. Thus, this is a clear case of delinquent being penalized without adherence to the procedure laid down in the discipline rules. In that apart, since opportunity was denied to the delinquent, it is a clear case of the breach of principle of natural justice. It is well settled that a penal action must not be taken without affording hearing to the affected party. But here the authorities have failed to adhere to the procedure prescribed by Rule 9 of the discipline rules and also denied due opportunities to the headmaster. Thus, I am of the considered opinion that the penalization of the delinquent under the impugn order dated so and so is legally unsustainable. So second case by division bench, my lord, similar line.
So this is on the procedure for imposing penalty.
Procedure, my lord.
It has nothing
This
to do
is
with suspension.
nothing to do with suspension, but this is as regard, my lord, penalties under 7.1 to 7.3. Where
On
this
penalty, your point
censury
is accepted, subject to what he says, that even in case of censure,
yes,
as per 12B,
yes,
the authorities ought to have intimated him
yes,
that these are the allegations and this is the penalty we want to impose.
yes.
And then on his response, instead of imposing any penalty, they could have closed the matter on censure.
Yes,
That would have been acceptable under the rules.
yes,
But they have not done
they
it.
have not done it.
So that is insofar as the penalty is concerned.
Penalty censure.
Therefore, the penalty of censure and the subsequent penalty were bad.
Bad.
So the second penalty was interfered with, but even the censure is bad. That's your argument.
That's right.
Insofar as your reinstatement after suspension or by revoking the suspension is concerned, that in that you are saying that this revocation was done and the period was adjusted against my leave. But that was not the correct procedure.
Procedure.
What is the correct procedure?
Procedure is that you will have to follow, give me, my lord, show cause notice. Notice has to be given. My lord, one judgment I will give your lordship.
No, where is that procedure? Notice has to be given. That's what I'm asking.
On the basis of the 54 1B I have shown, your
Hmm.
lordship will kindly see, I have given
54 1B or 54 B1?
54 capital B 1, then small b. This is quoted and that is the conclusion reached. And otherwise also 54 B1 is clear that for the purpose of treating the period of suspension, one has to.
This is an order of the Central Administrative Tribunal.
Dambaru Pathak's judgment, my lord.
But is it binding on the court?
Not binding, I'm just showing only for the purpose of showing that under 54 1B, show cause notice has to be given for the purpose of treating the period of suspension in a manner.
There are
which is
judgments of this court. We haven't got it.
I did not get it, my lord. I was told, my lord, this judgment is.
Perhaps the judgment has been authored by myself.
Yourself, your lordship.
I cannot use it as an authority.
No, I know.
Then-
No, your lordship cannot use it as an authority, but reading of the provision also is clear that that judgment.
Let us
only
read
shows-
54 B1B again.
Yes. When a government servant who has been suspended or is reinstated or would have been so reinstated but for his retirement on superannuation while under suspension, the authority competent to order reinstatement shall consider and make a specific order. Number B, whether or not the said period shall be treated as a period spent on duty.
So that order he has passed. The appellate authority has passed.
Appellate order, matlab 3 orders they have passed.
Hmm.
This is not a penalty under matlab Rule 7 of the disciplinary appeal rules. This is,
So authority competent to order.
yes,
The chief engineer has passed that order. Is
Passed
he
the
not
order.
competent?
he is competent to order, but for that purpose, you will have to give me a show cause.
Where is that required?
That is the requirement, my lord. That 5, my lord.
Hmm.
5 and 7.
Please read it once.
5 in the middle again.
Hmm.
I'll read it, my lord. In cases other than those falling under sub rule 2 and 3. Sub rule 2 is in case of my lord, 2 and 3, my lord. Otherwise, the government servant shall, subject to the provisions of sub-rule 8 and 9, be paid such proportion of the full pay and allowances to which he would have been entitled had he not been suspended, as the competent authority may determine, after giving notice to the government servant of the quantum proposed and after considering the representation, if any, submitted by him in that connection within such period which in no case shall exceed 60 days. And 7, in a case falling under sub-rule 5, the period of suspension shall not be treated as period spent on duty unless the competent authority specifically directs that it shall be treated for any specific purpose, provided that if the government servant so desires, such authority may order that the period of suspension shall be converted into leave of any kind due and admissible to the government servant. The payment alone. So this rule says, my lord, this is not a penalty under Rule 7. This is for the purpose of treating the period of his suspension or treating the period when he was not on in service in a particular manner, my lord. So for doing that, that charge sheet is not required, neither distinct, but you will have to give a charge notice to him after hearing him that why your service suspension period should not be treated as a leave on, shall not be treated as a leave. So there, my lord, Justice Damuru Pathak in his.
Right. You want to read this paragraph?
No, that paragraph, my lord, I have given the judgment to your lordships.
Oh, acha, you don't have another copy. You can read it from. You want it back?
I have given one copy to your lordship. It should be in the book only.
Acha.
Well, I'll read this, my lord. The
Please.
above provisions show that when there is a question of taking a decision by the authority, in order to regulate the period of suspension, it entails a separate proceeding of which the government servant who has placed under suspension and after revocation of the suspension reinstated has to be given notice, and after considering the representation of the government servant, the period of suspension is to be regulated and also the quantum of pay and allowances is to be determined. So this is the meaning of this 54(1).
So this long and short of the matter is that what should happen to his period of suspension?
Yes.
That decision to be taken by competent authority after serving
After
a
giving
notice and after hearing it,
Yes.
which has not been done yet.
Once not been done because, and this order has been passed along with the order of penalty imposed, my lord. First, your lordship will kindly, they have imposed the two penalties, and they have treated the period of suspension, which is not the part of the punishment under Rule 7. So, and then on appeal manner, when the petitioner stated that no charge sheet has been passed, no inquiry has been passed, they have imposed that, they have dropped that that head assistant to senior assistant, they have dropped that, but they have retained two. One is the censure part and another is the suspension. They have not given any notice. So in the absence of the notice, my lord, the treating of the period of suspension is wholly illegal. This is my submission, and two judgments I have given. That is, my lord, in regard to penalties of censure and other.
Acha, this judgment is here. This is the judgment.
My lord. Because I find, my lord, that judgment consciously has stated the meaning of 54(b)(1). Meaning is that you'll have to treat it, but you'll have to give them notice. First, you must come into a conclusion that your leave will be treated in this manner. So a show cause notice has to be given. And the other part also, the division bench judgments, I have given to your lordship, but it is, the print is like this, my lord, because from very. This is by Honorable Justice Ullal Bhatt and Justice Srivastava, my lord. Paragraph 6, the above rules would indicate that even the imposition of minor penalties should be preceded by framing of charges and an inquiry as contemplated under Rule 9. The penalty of the nature imposed in this case covered by Clause 3 of Rule 7 cannot be imposed without resorting to the procedure for imposition of penalty laid down in Rule 9. So your lordship has gone through, my lord, before imposition of the penalties, after framing of the charges, they may give the censure and all. But my lord is correct in a sense, my lord, under Rule 912. Okay.
I've got the judgment.
No, no. No, what I was trying to say, my lordship says for censure, nothing is necessary. That is on the basis of the stages of the inquiry. Rule 912. While 912, it says it very clearly. Notwithstanding anything contained in this rule, it shall not be necessary to follow the procedure laid down in the preceding sub-rules in cases where it appears to the authority competent to impose the penalty at the initial stages of the proceeding that the penalty of censure would be adequate. But that is at initial stage. But if at any later stage it is proposed to impose any
You are
other,
reading which
no, 12. Your
Rule-
lordship, Rule 912. As regard minor penalty, your lordship given an impression that it can be imposed. It is correct, but that is at initial stage. But here the stages that they have gone far ahead. They have imposed penalty of reduction of my rank. Then they have imposed penalty of censure and also treated my period of suspension. First is that 11.
Yes, Mr. Dhar.
Diploma.
So there are two issues here.
My lord.
First issue is, would the censure being a minor penalty, would it have been imposed in contravention of the provisions of Rule 912?
912.
Because we have to
My lord,
inform the employee in writing.
my
and
my
tell
lord,
him.
I have the record with me, my lord. I have just received it. I have gone through it.
two documents, my lord, I have found, and that document, my lord, I can understand why this order was passed, my lord. My lord, I'm just this orange flex, my lord. These 3 pages, my lord, I'm just putting it before lordship for perusal.
So what is it?
My lord, one is that on 1st March 22, notice was sent to him for hearing, my lord. Fixing the date on 7/3/22. He appeared, my lord. His signature is there, attendance, that sheet. Then, my lord, he gives a petition here stating that he did not get some documents. Then thereafter, my lord, these documents, my lord, is his in between handwritten. He has, it's a sort of a prayer, my lord, that stating everything. Then he wrote, my lord, in his presence of the, my lord, all these officials, my lord. Moreover, sir, I have only 4 years of remaining service and I am getting trouble in all respect, along with studies of my children, as well as for the maintenance of 2 establishments. One is at Silchar and another is at RK Nagar, Karimganj district. He has signed it, my lord. Thereafter, my lord, the department has, my lord, interfered with in the appeal order on 9th March. My lord, interfered with his major penalty and only censure is left, my lord. So it is not, my lord, factually correct that he did not know, he was not present, he was not given a notice. He was here, my lord, on 7th.
That's not the point. We are not concerned whether he knows or he doesn't know. We are asking you, what is the allegation against the petitioner? And where do you show it from?
That, my lord, I have to go to the writ petition, my lord. Writ petition, my lord, it starts from page number 32. Page number 32, my lord, it's a show cause notice, my lord. First.
Where is it? Page number 32.
Of the writ petition, my lord. 25/2020. This is the first show cause notice, my lord. Later, these are all dropped. Show cause, my lord. Then, my lord, next page is
Just a minute. All right.
Then, my lord, next page. This is the writ petitioner writes to the additional chief engineer for inspection of documents, my lord. Then the next page, my lord, this is his reply. Show cause reply, my lord.
So, Mr. Das, you have not placed all these documents.
There are more coming, my lord.
No. I have not placed it because, my lord, on earlier occasions I have shown all this. But this order, this is in the writ petition, my lord. For my petition only is reading. There was no charges, no inquiry.
My lord will come to page 36.
Where is the charges, my lord?
Page 36,
Where
my
is
lord.
the inquiry?
Page 36, my lord.
This is what the division bench order has said. This is a
All right.
preliminary thing.
As far as this period of regulation is concerned, under 54B3, you give him an opportunity of hearing if he submits a representation and then pass a fresh
My
order.
lord.
Yes, I'm dictating.
My lord.
Censure will remain. There is
My
nothing wrong about it. You want to make any further
No,
argument?
division bench judgment is there. Division bench judgment, my lord, that unless there is a charges and my lord, the report is
My lord will
there,
come to page
the
36.
censure cannot be passed, my lord.
36, my lord.
No, but the rules are clear. It is not applicable. Other provisions are not applicable, provided he is informed of the allegation and what penalty is proposed.
No,
Both these
penalty
things have been done.
Penalty proposed is not there, my lord.
Come to page 36. What are you saying, Mr. Das? Therefore, you are asked to show cause as why prescribe penalties under Rule 7. That's all.
No, censure and all, man, nothing is there, man.
All right, you conclude your argument.
Specifically,
You conclude your
specifically is not there.
No, from your arguments, I thought nothing was there. It's
No,
not that, it's not
They,
correct.
they have not given any charge sheet. They have not,
All right, we'll deal with it.
inquiry report is not there. And they have not denied in their affidavit.
My lord, page 36 is the charge sheet. Page 36, my lord, of the writ petition,
This
my
is
lord.
the second show cause notice they have given on the.
Second
without-
show cause notice, my lord.
Without framing any charges.
Below, my lord, you will find a copy of the statement, updated allegations
My lord.
and charges as stated. The next page is charge sheet, my lord. Statement allegations.
No, then thereafter, where is the inquiry, madam?
Then page 39 is the charge sheet, my lord, charge framed. Page 39.
Oh, these are all there, Mr. Das. You are
My lord,
saying is
My
then
lord,
thereafter,
I was
no
even-
inquiry, my lord. No inquiry on this basis, my lord. Your lordship will kindly see what inquiry they have done.
no inquiry is required. That's the
On the-
law.
On the basis of this, my lord.
Absolutely.
They have not given any particular notice that you will be given, impose the penalty of sanction. Because on the basis of this, what they have done, my lord, they have brought my rank from the head assistant to senior assistant. This they cannot do without inquiry. my lord. Inquiry has to be done. Without inquiry, they cannot do it. And second, regarding the treating of the suspension period, that also they cannot do.
That they'll, if you submit a representation, they'll consider and pass.
Now it has to go, my lord. Now your lordship will, I think, my lord, it's a case for it.
That you will have to do.
That has to
Due to
go.
requirement of 54B3.
I know, my lord. Only, my lord, my officers got little carried away emotionally. That is why there is this mistake. They should have gone, my lord. I
Why
will
they got
advise.
carried away?
Means he came, my lord, and he apologized to the committee, my lord, that he is in fag on end of his retirement. And he in his, my lord, if you see his handwriting, my lord, my lord, it was so shaky. The officers told me over phone. He has retired now, the additional chief engineer. He was so sick, he could not write. That is evident from the,
Emotional.
and they got carried away, my lord, emotionally, this additional chief engineer. And that is why, my lord, they said only on that ground we reinstated him, or else we would have gone after him.
No inquiry, inquiry officer was not appointed. Where is the appointment of an inquiry officer? There is no evidence at all, man. Inquiry officer was not appointed.
So you do one thing, you initiate a full-fledged inquiry against him now.
My lord.
We'll set it aside, but we'll grant liberty to the department to come up with a full, that's what you want.
No, I'm not saying, well, I'm saying.
So, Mr. Das,
regarding-
be very clear what you want.
I'm
Otherwise,
saying, my lord,
it'll create
in
problem.
In the absence of the inquiry.
So if
proceedings-
that is the case, he cannot be exonerated. Do you want a fresh inquiry to be
No,
initiated?
that I don't want.
Then there is no other, please don't make any other argument.
That 54B or
54B, they will only consider.
Yeah.
When there is no problem, let's not create one for him. Art Mr. B.D. Das, Lani Senior Counsel, estate by Mr. Teacher Das, and Counsel for the writ petitioner. Mr. Ardhar, Lani Standing Counsel, PWD, appearing for the official respondents. Being inter alia aggrieved by the order of suspension. No, being inter alia aggrieved by the order of penalty dated
That your lordship will visit that
26.
page.
yes, 26/7. You want to say something, Mr. Das?
No, page
26/7/2021, issued by the Additional Chief Engineer PWRD, Barakbari Silchar, imposing major penalty upon the petitioner, and also the subsequent order dated 9/3/2022 passed by the appellate authority, partially allowing the appeal of the petitioner while maintaining the order of censure and adjustment of the period of suspension against leave available to the credit of the petitioner, the instant writ petition has been filed. Full stop. The facts of the case in a nutshell is that are that the writ petitioner hearing, while serving as upper divisional assistant, is it? While serving as upper division assistant,
Head assistant.
as head assistant in the establishment of
Respondent number 5, I think.
you think
It is executive engineer.
serving most probably in the
No, I'm saying executive.
Executive
Executive engineer
Borkfla at Katigora Territorial Road Division.
in the office of the executive engineer.
under the office of the executive engineer, PWRD,
No, I'll be
Borkola and Katigora Territorial Road Division, that is the respondent number 5,
This one, no, 5.
was subjected to an inquiry proceeding for alleged misconduct. Full stop. Initially, the petitioner was served with a show cause notice dated 20/5/2020, informing him of certain allegations, informing him of alleged misconduct committed by him, calling for his written response within a specified time frame. Full stop. After inspecting certain documents, the petitioner had submitted his show cause reply. Thereafter, on 14/9/2020, a second show cause was issued to the petitioner, indicating the charge brought against him, along with a statement of allegation, thereby projecting the penalties that are proposed to be imposed upon the petitioner. Full stop. It appears that the writ petitioner did not submit any statement of defense, written statement against the show cause notice, second show cause notice dated 14/9/2020. Instead, the impugned order dated 26/7/2021 was issued to him by imposing the following penalty. Page 52, double tick to double tick. Full stop. In the order dated 26/7/2021, it was further mentioned that the period of his suspension from 19/5/2020 to the date of the order shall be treated as leave under the revised leave rules 1934, and the said period will be adjusted against the available leave in the credit of the petitioner. Full stop. Agreed by the order dated 26/7/2021, the petitioner preferred an appeal under Section 5 of the Assam Service Discipline and Appeal Rules 1964 before the appellate authority. Full stop. The appeal preferred by the petitioner was disposed of by order dated 9/3/2022 with the following directions and observations. Quote from 61, page 61. Stop. Thus, it is apparent from the order passed by the appellate authority that although the major penalty of reduction in rank issued to the petitioner imposed upon the petitioner was interfered by the appellate authority, by the said authority, yet the penalty of censure was maintained. Full stop. That apart, the order directing adjustment of his leave against the period of suspension, adjustment of the leave available to his credit against the period of suspension from 19/5/2020 to 26/7/2021 was also affirmed by the appellate authority. Aggrieved thereby, the petitioner has approached this court by filing the instant writ petition. Full stop. Mr. B.D. Das Learned Senior Counsel appearing for the writ petitioner has assailed the impugned order primarily on two counts. Stop. Firstly, that the authorities could not have issued, could not have imposed even the minor penalty of censure upon the petitioner without holding a full-fledged inquiry proceeding based on charges brought against him. Secondly, the order to adjust the leave available to the credit of petitioner against the period of his suspension was not issued by following the mandate of Rule 54B of the FR, thus causing serious prejudice to the petitioner's interest. In order to drive home the points urged by Mr. Das, he has relied on two decisions, namely the judgment delivered in the case of Jamaluddin Lashkar versus State of Assam and others, reported in 2017 SCC Online Go 451, and another decision of the division bench of this court rendered in the case of Samaresh Chandra Bhattacharjee versus State of Assam and others, and another reported in 1992 SCC Online GAU 142, to submit that no penalty, including the minor penalty of censure, can be imposed upon a government servant without holding a proper inquiry proceeding. Full stop. Next para. Responding to the above submissions, Mr. R. Dhar, Learned Standing Counsel of PWD, has argued that although the initial order of penalty dated 26/7/2021 was not based on any inquiry proceeding, yet in view of the order passed by the appellate authority interfering with the major penalty of reduction in rank, the said issue no longer survives for consideration by this court, as an order of censure being as the penalty of censure being a minor penalty can be issued as per provision of Rule 9(12)(b) of the Assam Service Disciplinary Appeal Rules 1964 by dispensing with an inquiry proceeding. Insofar as the second grievance of the petitioner pertaining to adjustment of his leave with the period of suspension, as mentioned above, Mr. Dhar submits that if the petitioner submits a representation to that effect, the competent authority will consider the same and pass appropriate orders in consonance with the mandate of FR 54B(3) within a specified time frame. Stop. I have considered the submissions made at the bar and have also gone through the materials brought on record. Full stop. After the order passed by the appellate authority, it is apparent that save and except the minor penalty of censure, no other penalty is operating against the petitioner at this stage. The question that would, therefore arise in this case is as to whether was it necessary for the authorities to conduct a full-fledged inquiry by framing charges against the petitioner for imposing the minor penalty of censure. The answer, it is interrogatory mark. The answer to the said query lies in Rule 9, bracket 12, small a and small b of the Assam Service Discipline and Appeal. Hereinafter referred to as Rules of 1964. So and so. Full stop. In the above context, next para, it would be pertinent to mention herein that penalties that can be imposed upon a government servant under an employee of the Assam government have been laid down under Rule 7 of the Rules of 1964. According to Rule 7, small 1, censure is a minor penalty. Full stop. Next, Rule 9, bracket 12, bracket close A and B. No, then you write, as per Rule 9, 11, bracket 11. The disciplinary authority would be competent to pass an order imposing any penalty, including the penalties prescribed under clauses 1 to Roman 1 to Roman 3, both in bracket of Rule 7. Full stop. Rule 12A and B reads as follows. The quote Full stop. From a plain reading of Rule 12A, small a and small b of the Rules of 1964, it is thus clear that the disciplinary authority can dispense with the requirement of holding a regular inquiry into the allegations brought against the delinquent if the only penalty sought to be at the initial stage of the proceeding, if the penalty of censure is deemed to be adequate. Full stop. In the present case, it is the admitted position of fact that not only once the petitioner was served with 2 show cause notices, clearly laying down the allegation, clearly laying down not only the allegations brought against him, but also the penalty proposed to be imposed upon the petitioner. Full stop. He had also submitted his show cause reply to the first show cause notice. Full stop. At that stage, it was open for the authorities either to go for a regular inquiry by appointing an inquiry officer or to close the proceedings by imposing the penalty of censure. Full stop. That was undoubtedly, now before the inquiry officer is appointed, it is undoubtedly initial stage of the proceeding, and therefore the recourse under Rule 9, bracket 12A and 12B would be available to the disciplinary authority at that stage. First step. It is no doubt correct that Rule 9, bracket 12A and 12B could not have been invoked by the disciplinary authority to impose the major penalty of reduction of rank upon the petitioner. However, the said penalty has been interfered with by the appellate authority. First step. If that be so, the only penalty that survives at this stage is the minor penalty of censure, which would have been imposed by the authorities without holding any departmental proceeding. Full stop. There is nothing in the rules of 1964, which prevents the departmental authorities from imposing the minor penalty of censure without holding a regular inquiry if the same is done at the initial stage. First up, in view of the above, I do not find any justifiable ground for this court to interfere with the order of the appellate authority insofar as the same affirms the order of minor penalty of censure upon the petitioner. Full stop. The decision relied upon by Mr. Das in the case of Samaresh Chandra Bhattacharya Supra and Jalaluddin Lashkar Supra are not authorities for the proposition that the respondents would be duty bound to hold a full-fledged inquiry, even for imposing the minor penalty of censure at the initial stage, subject to fulfillment of the requirements of 9(12) bracket clause A, bracket clause B, bracket clause of the rules of 1964. As such, the ratio laid down in those decisions would not be of any avail to the petitioner in the facts and circumstances of the present case. Coming to the next issue pertaining to adjustment of the leave available to the petitioner in his credit against the period of suspension. Rule 54B3 of the FR period of suspension. It is the admitted position that the petitioner was placed under suspension and subsequently he was reinstated. Full stop. FR 54B deals with the requirement of law for in case of reinstatement of suspended employees. Full stop. Rule 54B bracket 3 reads as follows. You have to quote it. If the decision of the authority is to adjust the leave to the credit of the petitioner against his period of suspension, the same would undoubtedly have an adverse bearing on the petitioner. In such circumstances, the petitioner would have a right to make a representation against such a decision and also to be heard by the authorities before any final decision is taken in the matter. First up, such a requirement not only flows from the provisions of Rule 54B1, 3, 5, and 7, but such a view has also been expressed by this court in an earlier decision rendered in the case of Dr. Tapan Kumar Hazarika versus State of Assam and others, WPC number 2106/2023, dated 5/11/2024. Full stop. Situated thus, this writ petition stands disposed of by granting 4 weeks time to the petitioner with effect from today to submit a representation before the competent authority, making a prayer for his reinstatement from suspension, making a prayer that the period of suspension ought to be treated as period in duty by furnishing proper justification. If such a representation is submitted within 4 weeks from today, the same be considered objectively and in accordance with law and be disposed of by a reasoned order within 2 months thereafter. Full stop. If the petitioner continues to remain aggrieved in the matter, even thereafter, it will be open for him to approach this court once again by filing appropriate petition. The records be sent back. This you have censure permissible.
Censure only, the Lordship has recorded everything. The proposal for imposition of censure was not there from their end. I leave it, my lord. But I thought, my lord, that treating of the period as it is totally in violation of 54 B of the FIR, your lordship will interfere with.
No, yes,
That has not been interfered with.
we'll do it.
Then if the authority desire, they can seek
The
representation from
appellate authority, what is the appellate authority order?
chief appellate
Dated
authority
so and so
order
stands interfered with insofar as the same
9322.
9/3/2022. Insofar as the same deals with the adjustment of leave of the petitioner against the period of suspension shall stand interfered with.
Yes. And if they want to issue notice and hear me, my lord, they can.
No, you submit a representation.
Oblige.
Looking at the allegations, your client should consider himself very, very lucky.
But they were emotional, my lord.
He got away.
He got away.
He got away.
I don't know, but but anyway, these things are different. My lord. What we hear, what happens in the office, things are different.
Only because inquiry was not held. He came in, my lord. That's why, my lord, after second show cause, he came before this honorable court. That's why no inquiry
No, all
was.
right, that's okay. This is on a different,
Yes.
different platter we are saying.
Yes.
We are not on what has happened, but your client got away. That's what I'm saying.
I
With
think
the allegations that were there against him, there could have been serious trouble.
Allegations are serious. Probably they have nothing in the record, I think.
Yes.
Lordship, before my submission, I like to point out page 9, my prayers. Because prayer was in 1918, it is a prayer. Now, the person has been already retired by this 22,
Yes.
28 to 27. So
Consider his case for promotion.
Yes.
Now,
I am already retired. So in that case, my submission would be because this is a read court. Read court can go beyond the travel beyond this prayer. So at least my promotion may be considered like that because they have in their reply, they have admitted that I am actually.
when did you retire? When did your client retire?
I am retired on 28 to 25. This
28 to
February.
25. All right. And the prayer was
18, it prayer was in 2018. And in fact, I am a senior, it is admitted by the railway authority in their.
Mr. Raman,
Yes,
I'm willing to consider your prayer.
Lordship.
But the similar matter came up day before yesterday also, I think.
No, that.
I'm looking for.
No, I was, that day I was before this court. That matter is separate to this because he was after retirement, he filed this petition. But here it is on the day of his service, he filed this.
Correct.
This is the difference.
But after retirement,
Lordship.
that his case can be considered for promotion. Is there any authority? Do you have any authority on that? It will be necessary for me to write a judgment. Otherwise, this will be taking a long time.
I can bring the one judgment is there by Justice Salame, sir, in those times because I was.
Why didn't you get that authority? It will be easier for me to
No,
write.
I'll bring it, but not today. I am not able to get.
Achha, you don't have it today.
So because
See, if there is an authority, then the court will go.
Thing is this, my lord, our my lord, submission is that my lord, he is not eligible for promotion, my lord. My lord, even if he has retired, my lord, the facts remains the same. He wants the promotion. Now he wants the benefit of the promotion now, my lord, after retirement.
No.
But
See,
my lord, before that, my lord.
Just a minute. This matter will have two different components.
My lord.
First is on merit.
My lord.
He has to succeed in showing the court that on that particular stage, at that stage, he was eligible and qualified in all respects to be considered for promotion.
Yes.
But the authorities wrongfully did not consider. That is the first.
Right.
If he doesn't do it, then it's over.
Right.
But if the court feels that no, he has succeeded in that, then the second hurdle would be that now to ask the authorities to consider his case for promotion again may lead to, you may say that we have considered he is not eligible. So that doesn't give him anything. That direction we can pass, but that will not give him anything because the direction can be only to consider, not beyond that. So consider the authorities can again say, sorry, we don't find you fit. So we have to come up with a clear legal format This is the area and this is what you'll have to do. For doing that, an authority would have some bearing. So that's why I'm asking if it is there.
One judgment is there from our High Court in an IS case. So in that case, because that is Justice Salamesar was there, I was assistant solicitor at that point of time. That was the case that a SCS officer was nominated to IS, but his promotion was not considered during his lifetime. After his retirement, his benefit was given, then monetary benefit was given. That is Nurul Haq, still I remember. Then another case in Agartala, Tripura case. That is also same benefits were given. After retirement, the monetary benefits were given. So this is the case. So
do you have the
kindly,
judgments?
just now it is not readily available. Kindly give us some time. So
How much time?
let's see, May, because April I'll be out. I'll go for horse.
All right, he is already retired.
Because he is already retired.
All right, huh?
He is already retired.
No, that's all right. So there's no hurry. Mr. H. Ramal, our senior counsel appearing to the petitioner.
Sonal,
Assisted by Miss
Asnat.
Asnat, and a counsel, senior counsel appearing for the petitioner. Seeks posting of this matter again in the month of May 2023. So as to enable him to examine the legal issues and address the court. Mr. G. Gosaman and counsel is present for the respondents. Let the matter be listed accordingly.
So for that type of judgment, two judgments are yes.
Yes, please give it.
Okay.
Then it will be
I'll-
much
I'll
easier
try.
and.
I'll try.
Yes.
May it please your lordship. Lordship, here the petitioner was a cook in SSP. He was granted a outpass, and he could not come back in time. And he was brought back to his camp later on. And after that,
What has happened? Dismissal,
yes, lordship, removal from service. Lordship.
removal from service. Where is the order?
Order is at page 18, lordship.
Page 18.
This is the order, lordship, at page 18.
Yes, what is the date? 31/3/2017.
Yes, lordship.
So what is he doing all these years? 7 years?
Lordship, now he is at home, lordship, he is unemployed. And
So the charge is that he was striking or threatening superior officer, is it?
yes, lordship, 3 charges were framed, lordship. First one was striking or threatening superior officer. Second is insubordinate and obstruction. And the third is at page 19, that is violation of good order and discipline. This
Yes.
Against this order, lordship, the petitioner went for appeal.
No. Forget order. Then what has happened? An inquiry was held.
Lordship, summary force court was held and this order was passed.
And the charges were found to be proved.
Yes, lordship.
Then he went in an appeal.
He went in an appeal.
Then the appellate authority dismissed.
Again dismissed it, but when the appellate order was passed, in that order, lordship, his past service negligence and all that were considered, lordship. That could not have been done, lordship. That is bad in law, lordship. I have placed the judgment earlier, lordship.
Is that correct, Mr.?
No, lordship. In fact, I have got a decision of 2017 4 SCC, which states, lordship, that past conduct can be taken into consideration, lordship.
So have a look at this judgment. Have you seen it?
No, lordship.
You are saying it cannot be. He is saying there is a judgment which says the matter can be closed in 5 minutes, but it will go against you. You better come prepared. And is that the only ground?
This is the only ground, lordship, now.
Let me see.
This is in a rough paper, lordship, but maybe.
Which paragraph you want to refer to, Mr.?
Lordship, I have perhaps very bold.
There are two judgments. This judgment relies on Union of India versus Bishambar Das Dogra, reported in 2009, 13 SCC 102. And the one he is citing is 2017 4 SCC 507. So here they say that it can be taken into consideration. So then what remains in your case?
Let me go
Huh?
through, let me go through it, Lordship,
You
sometime.
want to go through it? We thought we'll close it today. You want some time? All right, we'll give him. On the request of Mr. C. Sharma, Learned Counsel for the petitioner, hearing of this matter stands adjourned for 2 weeks. Mr. R.K.D. Chaudhary, Learned DSG, is present on behalf of the respondents. All right, you examine it, see the judgments. If you don't have any case, then we'll close it. That's all.